Hello everyone. Today we will do the dictation practice of exercise 24, 25 and 26. The speed of the dictation will be 70 words per minute. So let's begin the dictation of exercise 24 first. Sir, this is the time to look at the performance of the general fiscal situation. I have listened with some attention to the remarks from the opposition. Everybody is worried. I heard my friend speaking and the honorable member who spoke just now also talked about the problems of the size of the deficit of non-plan expenditure, the question of continuing inefficiency or relatively less efficiency of public enterprises, or the fear of the debt trap. These are familiar battle crises on the side of the opposition. At the same time, if you heard the earlier debates, the demand on behalf of the state for the net added transfer of resources from the center to states is still growing. The pressure is mounting. There is a demand for additional subsidy and continuation of existing subsidies. Then, on the one side, we talk about efficiency in economic management. On the other side, we find different state government and particularly some of the neighboring state government indulging in populist approach towards repayment of loans from the banks or other sector of the government. Now it is very difficult to reconcile the economic rationality of the demand and the economic rationality of the comments that the opposition members are trying to make. Let us look at the hard facts. The question is whether the economy is growing in terms of growth rate of the GNP or not. The fact is that it is growing at a very fast pace. In fact, the expected rate of growth of real income in the current year is likely to be around 9%, which is much higher than what we have seen in the recent years. If you look at the sectorial composition of performance, then the food production, thanks to the bountiful monsoon and a more imaginative agricultural strategy, particularly the food production strategy, we are finding a better performance. Of course, we depleted our buffer stock, but as a result of the better crops and with some imports, we are trying to replenish our buffer stocks. Industrial growth has been very encouraging, although in the last few months there has been a tendency at deceleration, and we hope by the year end the things will level up and our performance in the industrial sector will be well above the recent performance. It should be crossing 10 to 11% mark altogether. I heard my friend talking about the consumer's price index. There is no doubt that it is in the rise in the consumer's price index, that the consumer faces the real punch, but the increase has not been as alarming as we think, particularly if we look at the recent drought and the risk of likely increase in price which did not take place. Now, so far as the consumer's price index is concerned, it is closely related to the liquidity in the economy. It is true that the liquidity is growing because disposable income has been growing because of different kinds of payments that we have committed, whether it is the sixth pay commission and the cascading effect of that in the rest of the economy, or the other salary settlements, dearness allowances, and all that. This leads to demand inflation. But on supply side, if our buffer stock position is right and releases are timely and adequate, all the operations both on the supply side and on the demand side of the buffer stock are efficient, then we should have no fears. It seems to me the very fact that the price index has not been rising at a very rapid pace shows that the supply management, so far as the essential commodities are concerned, has been somewhat efficient, and this has given us a relatively better balance with demand. Now, so far as the wholesale price index is concerned, it is very encouraging. As a matter of fact, there was a slight pressure, but if you take the latest figures, there has been a deceleration there. What is particularly encouraging is that in the agricultural product group, the rate of increase in the wholesale price index has been much less compared to the non-agricultural commodity group. However, the fact remains that the resource position of the governments remains under strain. When we talk of resource position, we talk of three components. Number one, what is the rate of the domestic savings, particularly the net figures have been under serious stress. Fortunately, the household sector performance has been good, but the performance at the corporate sector level and particularly the saving in the public sector of the corporate particularly has been discouraging, and much more discouraging has been the rate of the saving in the government sector. So this is one area where substantial correction is required in order to generate adequate resource for investment. The second component is related to revenue. Now, if you take the total revenue picture, the direct taxes constitute 14% and indirect taxes constitute 85%, which are increasing every year. Stop. Now translate this exercise in English and check from the screen. Get ready for the another one. Exercise 25. Making the above submissions, it is prayed to allow the present appeal and direct the respondents to appropriate the payment of rupees 1.25 crore towards settlement dues under the scheme 2019, and that discharge certificate be issued to the appellant accordingly. While opposing the present appeal, learned ASG appearing on behalf of the Union of India has vehemently submitted that in the facts and circumstances of the case, no error has been committed by the Honorable High Court in dismissing the writ petition and refusing to direct the respondents to accept the payment towards the settlement dues under the scheme 2019. It is submitted that admittedly the scheme was valid up to 30th June 2020, and the last date for payment of settlement amount under the scheme 2019 was 30th June 2020. That thereafter the scheme was closed and even the designated committees were also dissolved, and therefore, as rightly observed by the Honorable High Court, the Honorable High Court has no jurisdiction to extend the scheme. It is submitted that if the scheme is extended, it would create many complications. It is further submitted that in the present case, admittedly, no payment was made of settlement amount under the scheme prior to 30th June 2020, and therefore the prayer of the original petitioner to extend the time limit to make the payment of settlement amount under the scheme 2019 was rightly rejected by the commissioner, and the same has rightly not been interfered with by the Honorable High Court. Making above submissions, it is prayed to dismiss the present appeal. We have heard the learned counsel appearing for the respective parties at length. At the outset, it is required to be noted, and it is not in dispute that the appellant is entitled to the benefit of the settlement under the scheme 2019. The scheme 2019 came to be introduced on 1st September 2019, and the last date for making the application under the scheme was 30th December 2019, and in fact the appellant submitted the application in form number 1 on before the last date specified for making an application under the scheme. After the form number 1 is processed, the designated committee was to scrutinize the same and issue the final form number 3 determining the settlement. The final determination, form number 3, that the appellant was issued the form number 3 on 25th February 2020 and was required to pay the settlement dues on or before 25th March 2020. However, in view of the COVID-19 pandemic, the government extended the time up to 30th June 2020. Therefore, the appellant was required to deposit the settlement dues on or before 30th June 2020. However, even before the scheme 2019 came to be introduced, the appellant was subjected to proceedings under the IBC, which commenced when the NCLT admitted the application under Section 7 of the IBC. Thus, the moratorium under the IBC commenced on 11 September 2018. The COC approved the resolution plan on 4th June 2019, and the same came to be approved by the NCLT by order. Therefore, the moratorium under the IBC continued up to 24th July 2020. Under the provisions of the IBC, no payment could have been made during the period of moratorium. Therefore, the appellant was statutorily restrained from making any payment. There was statutory disability on the part of the appellant in making the payment during the moratorium. If the appellant had made any payment during the period of moratorium, the appellant would have committed breach of the provisions of the IBC. Therefore, it was impossible for the appellant to make any payment during the period of moratorium. Immediately on the moratorium coming to an end, the appellant approached the authority requesting them to accept the settlement amount under the scheme 2019 as per the form number 3. Such request has been rejected by the commissioner. On the rejection has been confirmed by the High Court. Therefore, the short question which is posed for consideration before this court is whether, when it was impossible for the appellant to deposit the settlement amount in view of the bar and the restrictions under the IBC, the appellant can be punished for no fault of the appellant. In a given case, can the appellant be made to suffer for no fault of its own and be rendered remediless and denied the benefit, though it was impossible for the appellant to carry out certain acts, namely to deposit the settlement amount during the moratorium. As per the settled position of law, no party shall be left remediless, and whatever the grievance the parties had raised before the court of law has to be examined on its own merits, as observed and held by this court. No law would compel a person to do the impossible. Stop, translate this exercise in English and check from the screen. Get ready for the another one. Exercise 26. We deem it necessary and appropriate to briefly refer to the history of the law relating to works contracts. Entry 54 in list 2 of the 7th schedule to the Constitution of India enables the state legislature to enact legislation providing for levying and collecting tax in respect of the sale, and purchase of goods. Article 286 of the Constitution prohibits the state legislatures from imposing tax on the sale or purchase of goods where such sale or purchase takes place outside the state or in the course of the import of the goods into or export of the goods out of the territory of India. The scope and ambit of the powers of the states to levy sales tax on goods involved in the execution of works contracts have been the subject matter of several judicial pronouncements. The decision of this court in state of Madras versus Gannon, Dunkerley and Company, reported in 1958, is the leading case on the subject. That was a case where the SSC's business primarily consisted of executing contracts for the construction of buildings, bridges, dams, roads, and other structural projects. During the relevant assessment year, under consideration, sales tax was levied under the Madras General Sales Tax Act 1939 on the value of materials used by the assessee in execution of the works contracts. The assessee questioned the levy of sales tax on the ground that there was no sale of goods as understood in India and therefore no sales tax could be levied on any portion of the amount which was received by the assessee from the persons for whose benefit it had constructed buildings. The Constitution bench of this court held in a building contract where the agreement between the parties was that the contractor should construct the building according to the specifications contained in the agreement and in consideration received payment as provided therein. There was neither a contract to sell the materials used in the construction nor the property passed therein as movables. It was held that in a building contract, which is one entire and indivisible contract, there was no sale of goods and it was not within the competence of the provisional state legislature to impose tax on the supply of the materials used in such a contract, treating it as a sale under the agreement between the parties. In a building contract, the title to the materials used in the construction passes to the owner of the land as an accretion, and there is no question of title to the materials passing as movables in favor of the other party to the contract. The expression sale of goods in entry 48 in list 2 of the 7th schedule to the Government of India Act 1935 must be construed in the same sense it has been understood under the Sale of Goods Act 1930, and to constitute sale of goods the essential ingredients are: first, there should be an agreement to sell movables; second, it should be for a price; and third, there should be passing of goods pursuant to the agreement. Thus, by virtue of this court's decision in Gannon Dunkerley, no sales tax could be levied on the amounts received under a works contract by a building contractor, even though it had supplied goods for the construction of the building. The decision of this court in Gannon Dunkerley was applied in various other decisions wherein courts were dealing with the issue of transfer of goods in execution of works contracts. One such example is the case of Northern India Caterers India Limited versus Lieutenant Governor of Delhi, reported in this case this court held that there was no sale when food and drink were supplied to guests residing in a hotel, and that the supply of meals was essentially in the nature of a service provided to the guests and could not be identified as a transaction of sale. This court declined to accept the position that the revenue was entitled to split up the transaction into two parts, one of service and the other of the sale of food items. Accordingly, the proprietor of the restaurant, who provided many services in addition to the supply of food, was not liable to pay sales tax on the value of the goods supplied by him. A summary of the position of law with regard to taxation of goods transferred in execution of works contracts before the enactment of the 46th Amendment is as: first, works contracts are indivisible, that is, the revenue could not split a single works contract into two, one pertaining to the provision of goods and another pertaining to the provision of services. Second, to constitute sale all ingredients as mentioned under the Act 1930 had to be fulfilled, and third, to determine whether a particular contract was a works contract or a contract for sale, the dominant nature of the contract was looked into on a fact specific basis via the terms and conditions of contract and other related aspects to overcome the effect of various judicial decisions. Stop. Now translate this exercise in English and check from the screen. These were the last exercises of this March 2026 Progressive Shorthand book. For doubts, you can write in comment box, and you can like, share and subscribe my YouTube channel. Thank you.